29th, 2021, and ask the Commission Secretary for information on today's agenda.
Each Commissioner has independently reviewed the agenda, and each has informed me there's no need to discuss the minutes of the open meeting of Thursday, July 22nd, 2021.
Move we approve the minutes of Thursday, July 22nd, 2021.
Second.
All in favor?
Aye.
Aye.
Each Commissioner has independently reviewed the agenda, and each has informed me there's no need to discuss notices associated with agenda items 2 through 8. The suggested minute associated with agenda item 9, agreeing to dismiss the complaint by joint execution of a consent agreement between the Commission and the respondent, and accepting the proposed consent agreement as drafted, which directs the respondent to attend the educational courses and pay all fees associated therewith. Assessing an initial forfeiture against the respondent of $7,000, directing payment of the required $700 surcharge to Diggers Hotline within 45 days, and assessing a conditional forfeiture against the respondent of $75,000, and directing payment of the required $7,500 surcharge to Diggers Hotline. The suggested minute associated with agenda item 10, approving the 2020 fuel reconciliation application and refunding the 2020 overcollected fuel balance in September interest at WEBCO's authorized short-term debt rate, using the class level allocation method, applying the corrected figure amounts per the comments. The suggested minute associated with agenda item 11, approving WPSC's 2020 fuel reconciliation application and refunding the 2020 overcollected fuel balance plus the remaining 2019 deferred credit balance in September with interest at WPSC's authorized short-term debt rate, using the class level allocation method with the corrected numbers provided by staff. Or the suggested minute associated with agenda item 13, accepting WP&L's filed 2020 fuel reconciliation application as filed and not authorizing a refund or a surcharge.
Move we approve the notices of investigation associated with agenda items 2 through 8.
All in favor?
Aye. For agenda item 9, docket 9300, PLI 111, I move that the Commission agree to dismiss the Diggers Hotline complaint by joint execution of a consent agreement with SR Construction and accept said consent agreement.
Second.
All in favor?
Aye.
Aye. Agenda item 10, move that docket 6630 FR 2020, I move that the Commission accept Wisconsin Electric Power Company's proposal to apply or direct that Wisconsin Electric Power Company returned its 2020 its refund amount at the corrected amount per the Commission memo with interest at the company's most recently authorized short-term interest to rate to ratepayers in September 2021 using the class level allocation.
Second.
All in favor?
Aye.
Aye. Docket, agenda item 11, docket 6690, FR 2020. I move that the Commission direct Wisconsin Public Service Corporation to return the refund amount with interest at the company's most recently authorized short-term interest rate to ratepayers in September 2021 using the class level allocation.
Second.
All in favor?
Aye.
Aye.
Agenda item 13, docket 6680, FR 2020. I move that the Commission accept Wisconsin Power and Light Company's 2020 fuel reconciliation application and the requested finding that no refund is due to ratepayers or no surcharge is owed to ratepayers.
Second.
All in favor?
Aye.
Aye.
Aye. Okay. Take to agenda item 12, which is docket number 4220-FR-2020. This is Northern State Power Wisconsin's 2020 fuel cost reconciliation plan. In their application, they stated that they had total monitored fuel costs that were 0.41% more than what was authorized in their 2020 fuel plan. But that 0.41% is below the plus or minus 2% fuel cost band. They also notified us that their 2019 fuel cost return to customers was less than what we authorized by about $500,000. It's $483,507. So as it relates to their 2020 fuel costs, because they're within the 2% band, no refund or surcharge is applicable. And I think that there was maybe an inadvertent typo
On the alternative, yes.
on the alternative. So because they're within that band, we don't have to authorize a refund or a surcharge in that dead band. And then as it relates to the 2019 over recovery, they sought and they had comments filed by other parties. They had sought to sort of roll in that remaining $483,000 plus interest into their 2022-2023 test year rate application. And the parties to that settlement did file a comment in support of that. I just continue to believe that it's important to get these dollars back to customers as quickly as possible. And recognizing that that is a part of the settlement, it's a relatively speaking, it's a very small amount. So I wasn't in favor of allowing them to roll it into their rate case. I was at alternative one, where I would have them refunding those dollars back to customers in September of this year using that class level allocation. So as it relates to 2020, I'm at a modified Alt 1, which is accepting their 2020 fuel reconciliation application as filed and not authorize a refund or surcharge. And then for the 2019 over recovery, I'm at Alt 1.
Thanks. Yeah, I'm same on for the 2020 fuel reconciliation, same with that correction on the alternative one, accepting it as filed. I'm usually, my instinct always is to give, if this is the ratepayers' dollars, give it back. That is the default, and that is, in fact, what the rules say to do. But I have in the past, if it is part of a settlement and the parties have consented to it, deviated from that, because it's not that it's not going back to the ratepayers, it's just been embedded in that give and take and back and forth. It will go back to them. And with their rate case being next year, there's not going to be much of a delay in it. So I was fine accepting it and allowing it to be refunded in the 2022-2023 test year application. So I was at alternative 2 on the 2019 over recovery.
Okay. Commissioner Huebner?
As to 2020, I was in the same spot as you, accepting it as filed. For 2019, I can join you, Chair, and have that money refunded back to customers. I think that, in general, that's a good proposition, and although I know in the past we have done with that with settlements, this is such a small amount that I think it's fine to do that, so I'll join you.
Okay.
I'll stay where I'm at.
Okay.
I do 2 motions
Yeah.
for the 2020.
So for the docket 4220 FR 2020, I move that we accept NSPW's file 2020 fuel reconciliation as filed.
Second.
All in favor?
Aye.
Aye. I do, yeah. I closed this because I thought we were done. Sorry, let me get to this adjusted minute. So for 2019, I would move that we refund the money, the 2019 over collection in September of 2021 at the class level allocation.
Second. All in favor?
Aye.
Aye. Those opposed?
Aye or no? No, yeah.
All right. The next docket is agenda item 14, which is 3270-FR-2020. This is Madison Gas and Electric's 2020 fuel reconciliation. They have overcollected their fuel and purchase power costs by a net impact of about $3.2 million when you adjust it for the 2% fuel cost tolerance band. They, similar to NSP, are requesting authorization to utilize that deferred credit balance to offset rates in 2022 instead of returning them to rates in 2021. And I'm going to be the same place I was with all the preceding reconciliation cases. I think that it's important to get these dollars into the hands of customers. I understand that there's a timing issue here, and they had said, well, if we can't get to agreement by date certain, then we will come back and refund it. But just in terms of administrative efficiency, I think that they should go ahead and refund that 2020 overcollected fuel balance in September of this year with interest at their authorized cost of short-term debt rate, which is alternative 1, subalternative C. Commissioner Nowak?
At the class level. Yeah, I agree here. This is different than the one we just discussed. There's not a settlement, although based on the information here, there's discussions, but not having one in front of us, I think this is the best avenue to do, and you said for administratively easier rather than waiting to see what happens. So I agree with you. I'm at the same spot, alternative 1, subalternative C.
Okay, and I'll join you both at that.
Okay.
In docket 3270 FR 2020, I move that the MG&E be required to refund the 2020 over-collection fuel balance in September 2021 with interest at their authorized short-term debt rate at the class level, using the class level allocation.
Second.
All in favor?
Aye.
Aye. Okay, that moves us to our final agenda item, which is agenda item 15, docket 5-CE-146. This is West Cardinal Hickory Creek Transmission Line case. On June 28th, 2021, ATC and ITC requested that the Commission rescind the final decision granting the CPCN for this project and reopen the docket to consider next steps. We talked about this at our open meeting of July 1st, and we then served a notice of intent and request for comments. And the whole purpose of that was to hear from the parties and members of the public as to what they thought the next steps should be, because this is pretty unique. We've never seen something like this, and we agreed that it was important to get input before we moved forward. And remembering again that the procedural steps that are available to us could vary, that it wasn't necessarily one or the other, but that we had a number of avenues available to us. So we set a timeline of having initial comments come in July 12th, and reply comments were due a week later, July 19th, and then we proceeded to reopen the docket for that limited purpose of just receiving comments. We received a number of comments, and just in general, at the outset, we do read the comments. In fact, there was one comment who said, "Are you really reading the comments?" The answer is yes, we do read them. And really, the comments are a way for us to be apprised of maybe a path that we haven't considered or that we haven't thought about. And I think it's a very useful tool. And whether it's a rate case or a construction case, we do get a number of comments that are filed in the record. And they're an important part of the record, and we read them. What I was a little disappointed about is that I was hoping for a little more substance on the procedure and steps that we could take. What I found was it was a lot of rehashing of arguments in opposition to the project. And similar to what I said when we initially discussed this project, it's not that the arguments in opposition to the project are being ignored. That's not the case. It's that the evidence in the record, in my mind, tipped the scales that the project was in the public interest. And that's our job, to balance those. So I was a little disappointed that the comments weren't more, I guess, instructive is a way to say it. And then I was really hoping when we set the schedule for reply comments that we would be able to foster a little bit of constructive dialogue between the initial and the response, and that just didn't happen. So I understand. It doesn't sort of negate my belief that the public comments and the ability of the public to comment on our procedures is important. I think it continues to be important. I think in general, I just thought that the comments fell a little short. Then a couple of other things that came up that I just wanted to address, and I've seen this as kind of a common thread. And for frequent flyers that are here, you know that sometimes some of us come in and say, I'm kind of between alternatives. I could go with Alt 1, I could go with Alt 2, I want to hear from my colleagues. From my perspective, when we have a case that entails thousands of pages of documents and exhibits, multiple parties, technical hearings, public hearings, and a large record that was compiled not by any of us, but by an independent administrative law judge, I didn't come into that decision undecided. My remarks were pre-scripted. I knew where I was going, and I think that's a really important point to make, that neither Commissioner Nowak nor Commissioner Hipsch swayed my decision in any way, shape, or form. And maybe that happens in some cases, but it didn't happen in this case. I sat through the public hearings, I sat through the technical hearing, I read the evidence, I read the public comments, and I came in, again, with scripted remarks. I don't think Commissioner Hipsch was biased. I don't think the record in front of us is flawed, and there's nothing in the record that has changed from the day I made my original decision. So that original decision was based on the record that we had in front of us. And it was a fulsome record, and the determination in my mind that the project is needed to serve the public interest rested solely on the evidence that was provided to me when I made that decision. There hasn't been an argument that that record was flawed. If there was a material omission, if there was a material error of fact, if there was a material error of law, I could and I would be then inclined to go back and reopen it for the purpose of fixing the record. And we've done that in the past. But I don't think that's the case here. So I guess that's a long way of me saying that I don't think a rescission is necessary because nothing's changed from the day that I made that original decision. The record that I relied upon, the procedure that we followed, I continue to stand by all of that today as we're sitting here. And it's very clear that we have jurisdiction. There are all sorts of comments sort of questioning our jurisdiction and somehow confusing the matter that because a lawsuit is filed that all of a sudden we're divested of our jurisdiction, and that's just flat wrong. We do have jurisdiction. We have wide jurisdiction, and our jurisdiction and our discretion is very plainly stated in the statutes. You don't need to go beyond the statutes. You don't need to sort of do legal gymnastics to understand what the statutes say. So we do have the jurisdiction if we so choose to reopen the proceeding, but I'm not there right now. So I'm at Alt 2, which is do nothing.
Okay. Let me just make some preliminary remarks as well, and then I'll tell you where I'm at. And I want to thank everyone for the comments, and like you, did read them all, and was disappointed as well that some went back to re-argue what is already in the record, but you know, that's fine. I still read them. A lot of them, what I found was as a whole, the comments were contained anywhere from facts, opinion, and speculation. And so our goal, of course, is to weed out and find out what are the facts and what the correct law is. As one of the commenters put in the comments, the goal is for results to be based on law and facts. And that is exactly what we all strive to do here every time we meet. One of the things too, and thank you for, I think, bringing up again how we sometimes arrive at decisions, you know, come in after reading the record, you know, where we're at, but still listen to each other as things may change. I also believe that Commissioner Hipsch there was no evidence of him being biased. In fact, the unrebutted testimony so far is that there was no bias. And I think it is important to understand what a prohibited ex parte communication is, because there's been a lot of comments about those communications and what happened. So I know you know what it is, but for everyone, I just want to read what a prohibited ex parte communication is, and it's found in Wisconsin Statute 22750. And it's a communication to the administrative law judge or any agency official or employee involved in the decision-making process, and here's the key, pertaining to the merits of a contested case. The definition also includes a threat or an offer of a reward. I think that is an important definition, that, you know, we can all have different opinions of things, but you have to work from the same set of facts and law. And I think it's important to put that out there. So going forward, yes, I also agree with you. I thought you put it well. We do have jurisdiction to consider rescission. The statute is absolutely unambiguous that we may reopen a commission decision at any time, and really the inquiry stops after that. It's a clear statute. I also thought it was problematic for some of the interveners who initially in the comments said we did have a jurisdiction to rescind, and then made a different comment later. And also it is contrary to decision or statements they've made in filings in federal court as well about whether or not we have jurisdiction. I know that the Driftless Area Land Conservancy and Wisconsin Wildlife Federation argued in federal court that we could rescind the CPCN and the eminent domain authority it grants. So in essence, I agree with them. We can do that. And I agree that we certainly have jurisdiction to do it. So while the applicant said they didn't make their request lightly, I also did not come upon this decision lightly either. And that's because I, like you, will not concede that our process was tainted or that my fellow commissioners have been tainted. And however, while I disagree with the circuit court's preliminary findings as a matter of judicial and administrative efficiency, and at the request of the applicants and based on the filings of some of the interveners at certain points in time, I do believe it's in the public interest to rescind the order. And should the court determine the bias allegations have merit, the resulting next steps would be exactly the same as what the applicants are asking for right in the court. As a further, I think, basis for reopening, should we, after reconsideration, review, revote, approve the project again, the applicants have stated that the project is time sensitive in order for ratepayers to achieve those savings. Arguments have been made that even if the court were to rescind the CPCN, you or I are precluded from participating in further proceedings. I think that's based on a misreading of the judge's May 25th preliminary order, where in fact he said it 4 separate times that if he were to find Commissioner Hips was biased, he would have to vacate the entire decision and remand back to the PSC for further proceedings. Nowhere in that order did he say that you and I could never hear this case again. In fact, the case law supports that where a decision-making body was found to have a biased member, or at least the appearance of bias, courts have remanded the decision back to the decision-making body, and then the matter was reconsidered without the alleged biased decision-maker. And I think, we have the Maris v. Cedarbrook case, which is very instructive here. And here I think it's important, and we can have a further discussion. I understand where you're at, but I think, and as you noted, the record, there's been no allegation that the record's been tainted, and that's why I don't think the record itself needs to be reopened. In fact, it's clear from, I think, some of the public comments, they think the record's anything but biased towards the position of the applicant. So our administrative law judge, Mike Newmark, he developed the record. He was responsible for its validity. There's been no allegations of bias against him. So to me, there is no reason to reopen that record. And again, as you noted too, case law and the statutes give us a broad authority how we conduct our process going forward. There has been suggestion that, well, if it comes back to the PSC, staff can do it or a reserve judge can do it. Nowhere in the statute is that found to be a viable avenue. On a administrative hearing review that the court has, he has limited ability of what he can remand, and then he sends it back. He cannot craft new remedies. It's not sitting in a court of equity. So I know that those ideas were floating out there. They're just not viable. So I believe we should rescind it just as a matter of efficiency. To me, this continued, it's a matter of time why there needs to be all the further issues going on in state court about a commissioner that's not even here anymore is it's a waste of everybody's time. I don't care where you believe in this project, where you're at. So to me, we should the process I propose is just exactly what a court could do, and let's just do it and be efficient and move forward. So
you would rescind, and then what would your next steps be?
Well, I would be open to, obviously you and I would have to re-review the record. We've read it, but it's important to go back and refresh our recollection and look at it again. Be open to having a discussion from the parties only on information only in the record. We've done an oral argument before on a different case, limited, and then we take another vote on it. I think the record, there is no allegation that that record is biased, and that would also be a waste of administrative time and parties' time to refile that. And however long it takes, I don't think we have to set a date for a revote. I think when you and I are prepared to address that, we have a few other things going on here at the commission as well. So I think that's just if that's where we're going to end up, then, and that is what, the irony here is this is what the plaintiffs in the lawsuit have been asking for. So I think it's in everyone's best, to, again, have these protracted proceedings about someone that's not even here and can never hear it again is, again, an inefficient thing to do.
So one of my concerns about going down that path is the potential to sort of set things on a slippery slope, right? Mm-hmm. So we've never seen this before, this type of a request. And part of me says we've never seen it before because it might not be the best method of going about it. And I worry that in the future, if I were to agree with you and say, okay, let's go ahead and rescind it, are we signaling to applicants in the future that, okay, if you guys don't like what you see in a final order, right, or if you're being dragged through litigation, then you can just come back and we'll do kind of a take back. That doesn't sit well with me.
No, I understand that concern too, because every day people disagree with what we don't like, and but this is, I think, the litigation that's been going on is a bit extraordinary, and I'm not sure that every litigant has the resources and ability to do what's going on here, and it's really going beyond sometimes the scope of the issue before us. And our decisions here, we aren't bound by one decision in one case with another. So, while at the same time,
Okay, we're back from a break. Commissioner Noah.
Thank you. And sorry, it took a little longer than expected. Just was walking through some options. I think you and I there's a lot of fundamental things we agree on here. I think it's just a process moving forward, and perhaps as a bridge or to try to find some common ground. I don't know if you would consider because I agree with you that that final decision and the whole process there, it was a valid process and a valid decision. And so, and your desire is to not rescind that final decision, but if we were to stay the effective date of it, and that way it preserves the record, but it would also allow for us, you know, given everything that's going on, to accommodate some additional procedures to, I think, address some of the alleged issues but concerns people have raised. And I think this would bring some, again, efficiency and certainty to our process. Again, we can't control what happens outside of this room or in the courtrooms, but just to try to bring some efficiency and certainty to our process with this, if we were to stay the effective date of that, have an opportunity for parties and interveners to, I like the idea of doing an oral argument rather than having more briefs to read. The volume on this is already large. Again, confined to the existing record, and then concluding that at some point we could affirm, reverse, or modify that earlier decision. Again, it brings finality and I think certainty to the process. So don't know if you would consider doing that moving forward, rather than, obviously we're in different positions before we broke. So I offer that up and I'd like to hear your response.
So I guess just as an initial reaction, the first question that jumps to my mind is, if we determined that the public interest requires the project, right, and we've heard that time is of the essence, then staying the effectiveness of the order is akin to delaying construction, right? And so again, I come back to, and I do think a suggestion of oral argument is a good suggestion. But then I come back to, but why? Because there's nothing that I need. There's nothing further I need in terms of the record or argument to change my mind, I guess. So that's again,
the only, yeah, it's just, to me, you know, there's been a lot of allegations about procedural irregularities, at least with one commissioner, and for you and I to hear it, you know, without, you know, much has been made about Commissioner Hips leading the discussion. Right. Someone has to.
Just because I get sick of talking all the time.
Someone always has to go first. There would be an awkward situation if no one ever led a discussion. But that's, yeah. It would just allow that process. Does it delay some construction? Perhaps, but you know, everyone wants certainty and efficiency, and I think we can't meet all of them all at the same time. And I think that there is a need to, you know, if the pause is necessary in order to bring on that more efficiency and certainty in the long run, that's why I offer that up. So.
Sure, and I think it's a reasonable sort of middle ground, but I'm still where I was originally, and that I stand by our process. Mm-hmm. I stand by the fact that it was a really good record. It was really thorough, and I was not swayed one bit by Commissioner Hipsch. I also don't believe he was biased in any way, shape, or form. Yeah. And any action to rescind or to sort of rehash old arguments, to me, undermines, in my mind, it just undermines the confidence that I have in the record upon which I base my decision. And I understand that there are risks, financial risks, certainly, on behalf of the applicant. But I would throw out there, too, that instead of rescission, they also have the power to slow and pump the brakes and not continue down the path of construction. It doesn't necessarily have to be laid at our doorstep. And I just, as much as I try to sort of understand the benefit of either rescinding or, in your suggestion, staying, I just can't get past the fact that I stand by what we did. I full 100% have no qualms, no questions about the transparency, the veracity of our process.
Yeah, I do too. I mean, you know, particularly the timing at which a lot of this was raised is also, you know, interesting. But I also just look at the reality of where we're at, you know, and where our process is. And there is no great answer here.
Mm-hmm.
You know, it is in less than ideal situation, but this is the hand we are dealt, and I'm trying to just make the best of the situation for everyone involved, and for the process involved. And that's why I thought the stay, while we're not conceding that the process that led to the evidence being gathered and our decision-making process, there's no concession of that being inappropriate at all, because I agree with you. So you're at, okay, so I'll suggest, I mean, I will take your comments to heart. I assume you will do the same for mine. I think that we can, we can bring it back, and that's where my next step was. Obviously, we don't even talk about when we schedule things, but if you're ready to discuss this again, same as me, we'll have a discussion with council about just maybe the process. But I ask that if there is going to be a future discussion, it be very soon.
Absolutely.
Yeah,
right.
Very soon.
Right. Yep. And I think that from a scheduling standpoint, our open meeting next week conflicts with a scheduled court.
Yeah, I'll meet any day of the week.
Which is why we have one to accommodate that. So I would hope, I don't know this to be true, but I would hope that at that open meeting, we'd have the ability to hear from our counsel as to what transpired. And if that's the case, then we'll make sure that it's noticed properly, as we always do, and we could, you know, go into closed session to hear from our lawyer.
Okay.
And then if on the basis of that, we feel it's necessary to bring it up, then all we need is 24 hours notice, right? I mean, we could conceivably then meet again on Friday.
Or before. So, next week.
Right.
Yeah.
Yep. Yeah. Okay.
Matter is laid over. Yeah. I think we're done.
Okay. So that you. Oh. Yes.
Yeah, just state for the record that I am recused from this issue and won't be discussing it.
Okay, thank you. So that concludes our official business for today. The next open meeting is scheduled for Thursday, August 5th, 2021 at 1 p.m. Note the change in starting time.
Will we stand adjourned until Thursday, August 5th, 2021 at 1 p.m.?
Second.
All in favor?
Aye.
Aye. We're adjourned.